My name's Tori Edwards. I'm the manager and principal solicitor of the self-representation service at a community legal centre called Justice Connect. I wanted to start by echoing Gary and Jonathan's acknowledgement that we're on Gadigal land. Firstly, I guess a little bit of background about Justice Connect, where, as I said, we're a community legal centre. Our mission is fairness and justice through the power of pro bono. So we operate a range of different legal services that target unmet legal need in the community, and a large way in which we deliver those services is through leveraging the participation of more than 50 pro bono firms who send their staff to staff the services that we run. We're the product of the union between two organisations in New South Wales and Victoria, formerly known as the Public Interest Law Clearinghouse, or the Pilches. So Pilch Victoria and Pilch New South Wales merged in 2013, forming Justice Connect as we now are. I'll speak a little bit more to the self-representation service because I understand that's the panel's particular area of interest. But by way of background, some of the other services that we operate here in New South Wales include Mosaic, which is a specialised civil law assistance service for recently arrived migrants, refugees and asylum seekers. We operate our core business of a referral service which links marginalised and disadvantaged individuals with legal issues directly to pro bono lawyers through our membership model. We operate not-for-profit law, which is a national service that provides legal assistance to the community organisations that assist the people who usually fall in our client group. So its tagline's help the helpers, if you like, helping them to address their legal issues to free up their capacity to focus on their core business of assisting their client groups. And then we also operate the self-representation service, and more recently we've started doing some work in New South Wales, building on our expertise in Victoria in the health justice partnership space, particularly looking at addressing issues of elder abuse. So to return to the self-representation service, and we've had some helpful comments from Ms Honour earlier this morning about the context in which that service operates. It operates across the country in the Federal Court and Federal Circuit Courts pursuant to funding from Federal Attorney Generals. Justice Connect has the slice of funding that operates that service in Victoria, New South Wales, the ACT and Tasmania. So other organisations, our colleagues at QPilch in Queensland operate the service in Queensland. JusticeNet in South Australia delivers the service in South Australia and the NT, and Legal Aid holds the funding for the delivery of that service in Western Australia. And the model under which that service operates is really discrete, task-oriented or unbundled, if you like, assistance to self-represented litigants in the Federal Court and Federal Circuit Court across a range of jurisdictions. So the areas in which the Justice Connect service currently operates are, by the majority, I think probably more than 90% cumulatively across New South Wales and Victoria of our clients would have issues in either bankruptcy or fair work, mainly in the general protections area of the court's jurisdiction. And then to a lesser degree, we see clients coming to us with issues in human rights and discrimination applications or with judicial review matters, and that's predominantly for our client group in the social security benefits space, so reviews of administrative appeals of decisions of bodies granting benefits. I think that's probably all I'd like to say for the moment. Do the panel have specific questions about the service and the way that it operates?
Yes, if you could give us an example of a client to whom you've provided unbundled legal services.
Yeah, absolutely. So the way, probably to address both the issues of the client and the way that the model works, predominantly clients come to us referred by the registry. So as probably everyone in the room and watching would know, self-represented litigants most commonly present at the registry, and the court staff have been trained in conjunction with Justice Connect over the couple of years that we've been operating to know that they now have a service that they can send people to. So it might be that after being told of our existence by the registry, that potential client would contact us by phone or drop into the office that we maintain at the Federal Court building here in Sydney or in Melbourne. They'd explain to us the nature of their legal issue. For example, this client might have a general protections application that had failed to resolve at the Fair Work Commission, and therefore be looking for some legal assistance or advice about their right to appeal or to take that application, I suppose, to the Federal Court or Federal Circuit Court. We are touching on some of the issues that were brought up earlier about the involvement of students. We're fortunate to have practical legal training students working on the service, so most often either they or one of the paralegal staff would be the person who would take that inquiry from the individual, either on the phone or in person, go through the background of their legal issue with them to check their eligibility for the service in terms of area of law and stage of proceedings. Conduct a means test with them, so we're a means tested service, and then from there, if the person was eligible for our assistance, we'd be booking them in for an appointment with one of our pro bono lawyers at a later stage, excuse me, and preparing a fairly comprehensive brief to go to that pro bono lawyer prior to a 1-hour appointment that we'd booked them for, to enable that lawyer to have prepared as much as possible ahead of time and come to the appointment really ready to get as much done as possible. So we talk about the service being task oriented in the sense that that lawyer might be helping this individual draft their court documents. If they haven't yet filed proceedings in the court, they might be talking to them about, in a general protections application, whether it's more advantageous for them to commence in the Federal Circuit Court or the Federal Court. If they're a little bit later down the track and come to us already having filed, we might be talking to them about preparing for a first court date, preparing for a mediation, strategically considering what they might consider settling for if they've got a mediation conference listed, any range of issues. And along with all of those, I suppose, substantive pieces of advice that are given through the service, there's also a large amount of procedural advice, preparing people for an unfamiliar forum, preparing them for what's going to happen when they go to court, and trying to give them as realistic expectations as possible as to what they can hope to achieve through that process.
You're finding you're getting many people who don't qualify for legal aid?
Absolutely.
Support, but still can't afford to get legal advice?
Absolutely. Her Honour Justice Beazley's spoken and written extensively about self-represented litigants, and I know she talks about that growing middle bracket that really cuts to civil grants of aid have meant that not only in the self-representation service but across the sector and across Justice Connect's work, there is a huge amount of people who certainly couldn't afford a lawyer in the private market or couldn't afford a lawyer for a complex litigation like they might be running in the federal court, but don't qualify for legal aid. And I guess on the other side of things in the self-representation service, we also assist a lot of clients in bankruptcy, which certainly still a means-tested issue for the clients who come to us. They're all financially disadvantaged, but legal aid won't assist with a bankruptcy matter beyond giving very basic advice.
What are your funding sources?
So Justice Connect as an organisation has a mixed funding model. We get funding from federal, both Victorian and New South Wales state governments, a lot of local governments, and also increasingly from private ancillary funds from philanthropic sources. The self-representation service has got one sole funder, and that's federal Attorney Generals.
And is that at risk, that funding?
In terms of the self-rep service, we're into our third year of 3-year funding cycles. So our current funding agreement ends at the end of this financial year. We've already started consultation with federal AGs about, and that goes for the other self-representation services operating around the country as well. So we're in talks with Attorney Generals at the moment about the renewal of that funding and what level of funding we can hope to get.
Are there any other federal funds provided to your service?
No. We have one. We're fortunate, I suppose, fortunate in a sense to be subject to just one funding agreement.
What are the prerequisites for a client to use Justice Connect? Was the first question I wanted to ask you. And a follow-on, if I may, you made reference to only having one funding source. What's the future for your service if that funding is either lost or restricted?
That's a really interesting question. I think, and I can't speak broadly for Justice Connect's other services because we've got really mixed funding model. I think the difficulty, the value of a self-representation service is, to echo the judge's comments about resourcing in the courts, that so Justice Net, who operates the service in South Australia, have done a cost-benefit evaluation of the service and looked at the amount of money that's saved to the court system by providing this discrete targeted assistance to self-represented litigants. The logical funder for a source like this is, the relevant Attorney General's department in the jurisdiction in which it operates. I think, I don't want to publicly say anything about the security of our funding in future, but I think if the funding were to be either restricted or to disappear completely, we'd be in a really difficult circumstance because there is no logical other funder for a service like this. And I think, really, really wanted to pick up on the comments that Helen made about the difficulties that the sector is facing. Firstly, that fundraising is an incredibly time-consuming job. Most of our centres don't have, Justice Connect's fortunate and really unusual in the sector to have a dedicated fundraiser. Most CLCs don't have that luxury. And we're talking about people having to chase funding at the same time as doing the work that they ordinarily do. And as Helen said, I was nodding along listening, that it's really difficult to secure funding for core business work. So, for example, Justice Connect's referral service, which we would consider our core business, really difficult to get philanthropic funding for something as basic as linking people directly to a lawyer. Something that has incredible value and impact in terms of disadvantaged clients, but is not seen as being innovative or sufficiently sexy to warrant separate funding. So that can be a really difficult task.
Sure.
You are working on the doorsteps of the courts, the federal courts. Do you have any views about how the courts are operating, the delays that are occurring there, and the ability to clear cases?
Not even on the doorsteps. In fact, we're inside the building. We're very fortunate to have in-kind support from the court that provides us with an office in each of the Melbourne and Sydney court buildings, where we're often operating the service. Look, I think my observation of the delay from our perspective would be on the stress that it causes to our client group, the difficulties that they face in having matters before the court, and also the difficulties in terms of delivering an unbundled service to someone who might then go away and not actually have to implement that advice for some time. I think undoubtedly the resourcing of the court has also impacted the ability of the registry staff to be able to assist self-represented litigants in a way that they maybe once were able to, and that's the value of having a service like ours, that we can take some of that pressure off an under-resourced court system, and to go that step further in terms of being able to provide targeted advice to people.
And there's been some recent restructuring of the court registries, the back office function. Is that impacting on the registry's ability to deal with self-represented litigants?
Look, it seems to be impacting, and from talking to my colleagues at other self-represented services in different jurisdictions, it seems to be impacting different registries in different ways, notwithstanding that the court's obviously moving to nationalised functions. Things tend to operate a little bit differently from registry to registry. I'm aware that not every registry has a dedicated staff member who's responsible for dealing with self-represented litigants, and I know that that's something that exists in some state level courts and has been found helpful by colleagues. I think also the more recent budget cuts to the court, we haven't quite seen the impact of them in terms of back office functions as yet, or at least I don't feel that we've experienced them if they've happened already.